playing at Kristocentric.com. Kristocentric Station, the Kingdom Promoter.
It's an amazing morning right here on the Kristocentric agenda. My name is Yeboah Edwin Techi, and today I have with me in the studio Mr. Charles Boakye Esquire. He is a barrister and solicitor of the Supreme Court of Ghana and also a legal associate of Zoe, Akyea and Co. And what we'll be talking about today, we'll be addressing a very, very sensitive matter that's been spreading throughout the African continent and also in Ghana. Today on the show, we will be dealing with rape and forced rape allegations and having a look at these two things through the eyes of Ghana's law. So it's an honor and a privilege to welcome to the studio Mr. Charles Boakye Esquire. Good morning. I hope you're doing good.
Yes, please.
Okay, amazing. How long have you been practicing?
Yes, I was called to the bar on 9th May 2025. So from there, I've been practicing for up to a year.
A year?
Yes.
Wow, and in total, how many years?
Yes, in total, when I joined Zoe, Akyea and Co. in 2023, so it's getting to 4 years.
Wow. 4 years.
4 years of experience, but became lawyer in 2025.
Now, walk us through the Ghana's laws. What specifically defines the concept of rape?
Okay, so before I continue on with it, I would like to thank you for inviting Zoe, Akyea and Co. to have a contribution on this important topic, which affect the whole nation as well as the international community. I bring you and your audience greetings from Zoe, Akyea and Co. We are a full-service law firm operating from Laboni in the Greater Accra region. And specifically, we have Honorable Samuel Atta Akyea as our head of chambers and Mrs. Philippina Adelaide Akyea as our managing partner. Now, to your question, the meaning of rape in Ghana. Section 98 of the Criminal Offences Act 1960, Act 29, defines rape as a carnal knowledge of a female of not less than 16 years without her consent. Now, from this definition, one may ask, what is this carnal knowledge? When the law says carnal knowledge, it means that it is the penetration of a woman's vagina by the penis of a man. And the penetration need not be deep, or it need not get to an extent to which a semen is released, insofar as it is entered in what a manner that in law we call it brushwork. The penetration is said to has taken place and carnal knowledge has taken place. And we also say consent. And when we say consent, we are talking about consent that was given freely and voluntarily without any compulsion or force, or if the victim else unconscious or incapacitated or is in or any for any other reason unable to give consent, then rape is said to have been occurred. So that is basically the meaning of rape in Ghana.
So wait, with what you're saying, a man cannot be raped?
No, a man can never be raped in Ghana currently.
Wow. So in the instance where at the beginning of a sexual encounter, there is consent.
Yes.
But about halfway through, consent is withdrawn. If it continues, does it become rape then?
It surely becomes rape because under section 42J of our Criminal Offences and Identity Act 29, consent once given can be revoked. And so if during the sexual activity one person says stop or no, I don't wish to continue on, immediately you have to pause and stop wherever you have reached.
So wait, the law doesn't consider the level of involvement or the enjoyment that has gotten in case, like in the instance whereby you are engaged in a sexual encounter, you've gotten to maybe with you've gotten to a very a point where you can't stop.
Yes.
And then consent is just withdrawn. You have to stop.
Yes.
If not,
legally speaking, you have to stop. There's nothing like you can't stop. Because we have the way God created us, we have natural senses of even withdrawal during sexual activities, where it is the most intense or highest stage where you have your feelings. You can still withdraw. So as soon as a lady tells you that stop or I'm no longer consenting, wherever you have reached, the law demands that the lawful side has ceased. Once she says stop, it means she's no longer consenting. Or even if she doesn't say stop, but then when you look at her reaction, it seems that she is no longer interested, you are to stop.
even if she does not say stop.
Stop explicitly. So you are in your attempt to still continue to penetrate, she starts pushing you and exhibiting signs that she's no longer interested or she's suffering. Immediately you have to stop, because later on if she complains of rape and then the court examine everything that transpired and the evidence clearly shows that her attitudes, her reactions, her conduct speaks that every reasonable person ought to have been stopped at that moment, then you'll be faced with a liability, criminal liability, that you've committed the rape.
So can wives be raped?
Wives too can be raped.
Even within the confines of marriage?
Yes, because as I said, Section 42G of our Criminal Offences Act says that consent once given can be revoked. You know, historical context, brief one. In England, our law was modeled based on English law, where once you are married, it's deemed that you have the unterminated right or consent to have sexual intercourse. But then such provisions were repealed under Section 432J and it was revised. And now, by the work of the Statute Law Revisioner, which revised that portion of the law, it says that once consent has been given, it can be revoked. So if you are married and now your wife says that at this time or at this particular day, I'm not interested in having sex, I don't wish to have sex, I don't consent to the sex, or she exhibits any conduct that shows that a reasonable person ought to know that at this instance she's no longer consenting, then it's best that you stop, because if you don't stop, she can mount an action for rape against you.
So there's nothing like marital duty, as in a wife is supposed to provide sex for the husband, and the husband is supposed to provide this and this within the confines of marriage. There's nothing such as marital duty.
Because of this, there is. I will conclude that there is no the marital duty that at all cost give your husband sex if you, for maybe medical reasons, or at that time you don't wish to have sex with your husband. So, although there's a biblical duty, we can say so, but the law says it takes account of many things that were happening in the past, whereby husband has to beat their wives and subject them to tortures to be able to have sex with them in order to exert some force on them against their wish. So as a result of these practices, the law has to be revised to take account of that. That is why we say that it's proper that where you are being subjected to danger, or by force or intimidation, or a time that you don't feel like having the sex, it's best that your husband understands you and you don't have the sex. Otherwise, if he forces you to have the sex, then it's amount to rape, because consent once given can be revoked.
How many rape cases do you deal with every year?
Every year, Zoe Akyea and Co. able to have about 63 cases.
63?
Up to 63 cases from the public citizens of Ghana. And then we advise through. We are not the prosecutors, so some of them will call us and we direct them the appropriate way. You have to lodge complaint with the police, which is appropriate mode. But some of them too are accused persons who approached us that it's either they never did the act of sexual penetrating the vagina of the female without the female's consent. They never engaged in that, or is it that they were engaging in it, but from every angle the woman consented. It's just that after the act that she is accusing him of doing that. So we've been faced with many of these cases. Some are more than this is a three, but I'm just quoting the average number of rape cases that we receive. But we receive many sexual related offenses cases.
So out of this average of 63, how many actually proceed to court?
Yeah, so after the advice, for the complainants, mostly they're able to lodge the complaints with them. So I would say about 80% of the complainants that we advise are able to lodge their complaint. But for the accused persons, once there is a charge against you, there's a definite that we have to defend you, provided, of course, subject to the payment of legal fees, and then the pro bono if you wish to take your case on pro bono.
Wow. But when someone commits rape, what are the penalties that they could face?
Yes, rape is a first degree felony according to Section 97 of our Criminal Offences and 1960 Act 29. And then the punishment raised a person who is convicted of rape can be sentenced to a minimum of 5 years and then a maximum of 25 years. But with this, sometimes it is served with hard labor, often served with hard labor. And then there is no option of a fine in rape cases. It's strictly imprisonment from 5 years minimum to 25 years. And this account normally how the rape occurred, the circumstances, how they aggravate, whether the victim was gang raped, whether there was a use of offensive weapons to frighten, in order to exert the consent of the victim to do so, or the other many factors come to account in the court considers it in passing the sentence, whether mitigating or aggravating factors.
Speaking about we've just spoken about the charges or penalties for rape. Yes. But in Ghana, is making a false rape allegation a criminal offense?
False rape allegation, although it's not specifically created as an offense under a statute in Ghana, there are other offenses that the act of false rape allegation can lead to or give rise to. So, for example, We have publication of false news under Section 208 of Act 29. We also have false communication, and that one too is Section 76 of the Electronic Communications Act 2008, Act 775. We also have deceiving a public officer under Section 251 of Act 29. So when you give a false statement, when you report a case to the police, it's deemed that you will volunteer a statement to the police, and that one alone can land you with the charge of one, fabrication of evidence, because you have volunteered a false statement to the police that you have been raped. Then if the case actually goes to court and you give evidence on under oath, then it later proved that it never happened, then you can be cited or charged for robbery. For perjury, and it's also a serious offense.
Wow. In practice, how often do false rape accusers actually face prosecution in Ghana?
Yes, they rarely face prosecutions because because of the social stigma attached to the offense of rape. So most of them try as much as possible to settle out of court, which is illegal. That is not amenable to settlement, but the families normally withdraw because of financial constraints or some fear, certain pressures that from the society. Yes. And then you can come again so that I provide other responses.
So saying that, how often do false rape accusers, those that falsely accuse the other gender of rape, actually face prosecution in our country, Ghana?
Yes, so I said they really do, basically because of one, the stigmatization, and also the authorities have discretion to prosecute the cases. And so in order to give some of the victims, the genuine victims, the opportunity to come out and then lodge their complaint, they serve or try as much as possible to avoid prosecuting those who engage in false rape accusations.
So they are shielded?
Yes, in a way. Some of them, because of the prosecutorial discretion, Article 88 of the 1992 Constitution provides the Attorney General having the discretion to decide which of the cases to prosecute. But
doesn't it give people considering accusing someone of false rape the strength or the confidence to still engage in something like that, knowing that they will not, or is less likely they would face prosecution?
Yes, despite some of these things, once a complaint is lodged, if you lodge a complaint with the police that you've been falsely accused, so the person is supposed to be prosecuted for maybe publication of false news and all that, it has to be investigated. And if they don't have sufficient evidence, it may not, because one of them also is proving the malicious intent. It's normally difficult. That the person maliciously and through false mischiefs decided to report, allege that you've committed rape. So in that instance, it becomes difficult for the prosecutors to prove, and then the case may even fail.
So recently there was a case in Nigeria whereby a young woman falsely accused some people of breaking into her house to rape her. It was trending on various social media platforms. Then down the line, she said they pulled out knives on her, they raped her, she went to the hospital. But when they dug deeper, they realized that was not the case. It was a scheme to raise money. And there was another instance whereby a lady falsely accused a gentleman of raping her, called the police to arrest them. Then when they did the investigation, they found out that it was actually a lie. And she came out to apologize, saying that she did that because she was angry. In cases like that, bringing it to our context, what consequences would people like these face within the laws of Ghana?
Clearly, as it was published on social media, there is publication of false news, and that one is a misdemeanor. Is from 0 to 3 years imprisonment if you engage in such an act. And then they can also bring an action for false communication under section 76 of Act 775. That act, you can be liable for a penalty unit of 3,000 or for imprisonment for up to 5 years.
So penalty units of 3,000, how does that convert into actual Ghana cedis? How much is that?
Yes, I think the current penalty unit per unit here is 12 Ghana cedis.
Okay.
So you multiply by the 3,000, and then the amount that you will get will be the penalty matched against you. And also it can be both. It can be the 3,000 penalty unit without prison sentence, depending on how the allegation. But for this one that you just narrated, it's so severe that when you call the police and say that they robbed you and raped you and do all these things have severe allegations. And so you can be sentenced to an imprisonment for up to 5 years.
So in other words, the punishment...
And then I'm even coming. Let me add that if the person had called the police and volunteered a statement, that one too is fabrication of evidence. And also the same act will constitute the deceiving a public officer under section 251. All these things are misdemeanors that can land you from 6 months to 3 years. Yes, so at least the maximum is the publication of false news, which is can land you up to 5 years in imprisonment.
So the consequence of false rape allegations and that of rape and actual rape are not at par?
No, they are not at par. Because the rape itself, because the intrusive nature of it and how the society frown upon it, it's been given a heavy sentence. But this is just a mere allegation, and however serious it is, it may harm your reputation, which you can sue for damages in civil side. That is the thought of defamation. Or maybe if prosecution has started and it terminated, or you never convicted, but in the circumstances that you prove that it's false or there's a malicious intent, there could be damages for malicious prosecution. But it's never at par with the rape itself, because we consider it as first degree felony and it's very serious.
So can we say that the law, when it comes to these sexual activities, are skewed against men?
Yes, in the circumstances. Yes, in the circumstances you can say so, but before it's where I would say yes, I also say no, because one, it's yes because of how the offense has been defined in the exactly section 98 of Act 29, but also the accused person, before he can be, that is the man, before the man can be convicted of rape, there are a series of things. You have to lodge a complaint. The complaint has to be investigated. The police will even send you to a police hospital for you to get some medical evidence, medical report, to establish whether or not it actually took place. Not rape, but the act of sexual intercourse by force without consent took place. And the medical report will be able to establish that there are certain abrasions and lacerations in the vagina, which will show all these things. So, in all the also apart from this medical evidence, the Attorney General, who is to prosecute the case, will evaluate to see whether there are sufficient evidence. You, the accused person, once arrested, you are entitled to bail. So these are some of the protections. Also, the same accused person has the right to a lawyer of his choice to represent him in court. The same accused person ought to also be given the facility to examine the witnesses of the complainant herself. So all these things, we can say that the law gives certain protections for the accused person, unless it has been established beyond reasonable doubt that the accused person has committed the offense. So in a way, the definition has been skewed against men, but they are still protected under the law until a court of competent jurisdiction has pronounced that the prosecution has proved beyond reasonable doubt that the offense of rape has been, the elements have been proved.
How long does it, on average, how long does it take from case filing to final court verdict for the court to rule that this rape happened or did not happen? Is there a duration?
Yes, there is no strict duration or fixed duration. But court matters, many things happens, and such as sickness and all those things, absence from court adjournments and all this. So let's say within a year, it can complete for fast track processes, but it can even take up to 3 years, depending on how the case is going in court. Although Article 19, Clause 1 says that the person who has been charged has to be tried within reasonable time. Yes, so we try as much as possible that the person goes through the trial process as fast as possible, but because of the human inevitabilities, it may end up going to 2 years, 3 years or so.
Okay. When a false, or let's say a rape claim, a rape claim is made, what is the legal and investigative process for determining whether it is true or false?
Okay, so this answer can be distinct from previous answers I've said. So, one, the complainant first have to lodge a complaint with the police, and then volunteer a statement detailing what happened. And then the police, after taking the statement, will ask them to, or guide them to go to the hospital, normally police hospital, for them to be medically examined. Normally it's best that immediately after the act, you don't even bath, you go straight to the police station and after complaint, so that we know the extent to which the vagina has been, because if there is absence or there is lack of consent, there might probably be force, and the force, because of how God created the organ, will be subjected to certain aberrations and lacerations. And so the medical report will be able to state what abnormally have happened or unusual, apart from normal says what would have happened. So these are some of the evidence, and then the evidence from the crime scene and all that. So the police will gather all this evidence and do what we call investigation. And so if they merit certain evidence which causes a reasonable belief, then the police will arrest the accused person, or the arrest too can take effect before some of the investigations are made and placed in custody, so that the evidence will not be hampered and all that. So after the arrest and investigation, and police gather the evidence and know that at least there are sufficient evidence that we can prosecute on grounds of rape. Because rape is a first degree felony and is an indictable offense, the docket which has been prepared by the police is forwarded to the Attorney General. Attorney General will also look at it, examine the docket, and see whether there's a strong evidence that can substantiate the claim of rape. And then after that, we'll send the case to court and start the prosecution. During the prosecution, it is mandated that the prosecution or the Attorney General has to establish the guilt of the accused beyond reasonable doubt. So that is one of the protection. And the accused is not obliged to say anything. And even when accused is being called to the police to arrested and they are coming to charge and give him charge statement or caution statement, he need not volunteer anything, he need not say anything. He can just say that when it's my turn, I will then make the court know my side of the story. So the prosecutor has to prove all the elements of rape that he has been carnally known, that is, her vagina has been penetrated by a male's penis, and then 2, that male was the accused person, and that it was without the consent of the victim, and that the victim is a female of 16 years or above. If these elements are established, then prima facie there is a case for the accused person to answer. Then the accused person will bring out all his evidence. The accused person also have the right to examine to cross-examine the witnesses that has been called by the prosecution, including the complainant herself. So, looking at all these, the system has been designed in such a way that the accused's right will be upheld in all these processes, so that it will be only rare cases where a person who is innocent will eventually be convicted. And even if the person is convicted, and the person serves some prison terms and later found out on appeal the person never committed the rape, he can claim for compensation under Article 14, Clause 7 of the 1992 Constitution. So these are some of the procedural safeguards that the accused person may enjoy in order to establish for his guilt beyond reasonable doubt.
Have you dealt with cases, we mentioned rare instances, but have you experienced cases where someone has been sent to prison for rape, but down the line it has been proven that that did not happen and has later been released?
For now, we've not experienced such a case, but nationally there are some cases where people have convicted of rape and have gone to court. Some even spend as much as 15, 19 years in jail. And
15, 19 years?
Yes, because the person has to, maybe the person has been given 25 years because the circumstances of the surrounding circumstances which grounded the charge of rape. And so the court believed that the prosecution has established unreasonable doubt. And in that matter, sentence has to be imposed. They didn't believe his story until the complainant one day said that it never happened and all that. So in such instance, the Constitution says that irrespective of the robust system we are trying to create to deal with, to be able to separate the genuine cases from the false allegations, humans are infallible and we make mistakes, so a person can be convicted. So what is prescribed is that then in such instance there will be compensation from the Supreme Court of Ghana. The justice of the Supreme Court will determine whether the person is entitled to the compensation.
So they'll have to determine whether the person is
entitled. Even after that, they will examine although the court has to know whether, although you've been discharged on appeal, but the evidence there raises at least certain level of understanding that you might have committed it. It's because the criminal justice system, because prosecutor have to prove beyond reasonable doubt, your duty as a accused person is to raise only a doubt. So if you've been able to raise only a doubt, such a certain statement was not part of the process, so you could not be convicted, or because it wasn't part of the process and you were convicted by the High Court, but because the appeal has released, it doesn't entitle you automatically that you should go for compensation. The court will examine all these segments and say that reasonably you were wrongfully convicted. And from all indications, it wasn't any incidental procedural technicality. That is why you were released. So if the Supreme Court satisfy themselves with all the court processes, then the court will then come out with the conclusion that per the amount of years you've spent in prison and all that, the state should give you this compensation, but not to the extent that the state's purse will go down. Yes, so they just calculate and then do it.
But is the compensation ever enough to be able to say, for the 16 to 19 years I've spent in prison falsely accused, this amount is enough?
No, it's never enough, because that one will also drain the public purse. That's why the Supreme Court will even take time to examine whether in all the circumstances how, because there are many people in Ghana, maybe out of the prosecution's zealousness to prosecute, may have presented or painted a picture. You know how sensitive the sexual offense of rape is. And so you may eventually land in prison, and many people may have landed. So if all of them are claiming this compensation, the Supreme Court doesn't distill how each of them suffered, what they have gone through, whether it merited for me to give someone 500,000 Ghana cedis as compensation and someone 1 million Ghana cedis as compensation, and so the court will vary all this and then comes to conclude that you deserve this. But that one too, let me tell you, we have the general damages and then we have the specific damages. So the Supreme Court may award you general damages, but you have the duty to also establish that this and this and this and this is what I have suffered. I lost employment. I lost my reputation. Now, when I go home, none of my family members welcome me. Although I have been acquitted, but they don't seem to agree. I still have the stigma and other things you've suffered. If you're able to prove on a balance of probability, that is the standard, the court will award you certain damages for the wrongful imprisonment you have suffered.
Using the same instance of spending 16 to 19 years in prison, if it is then proven without any reasonable doubt that the complainant provided false information, now you have been released from prison, does that person face any kind of consequence from the law, not from the person who has been released?
Oh, okay. Basically, because there should be someone who is to trigger it. So if the police got aware, becomes aware of these circumstances, they themselves can take up the case and take the false accuser on. But normally, it's supposed to be initiated by you who have suffered. Because we have civil remedies that you can go under, and we have criminal remedies. For the criminal remedy, you have to point out to the prosecutor, because they have many cases to prosecute, so they may not have time to personally take it. But if it comes to light to the public, and out of public agitation and all that, they will come in and then prosecute. Personally, they can take up the case, or some NGOs will help you to voice out. Otherwise, you have to take some steps and lodge a complaint with the police on false publication of news, false communication, and then maybe perjury, on fabrication of evidence, on deceiving a public officer. All these kind of offenses can be brought. The person can be charged under. So after all these criminal remedies, you may say that no, I want something apart from the constitutional compensation. I want the person to then be sued for my damages that I have suffered. So one, reputational damage for defamation. Then we have damages for malicious prosecution, because you've gone through all these things, all these processes, and you've been prosecuted. Later on, it's found out that you are not the one. So you have damages for malicious prosecution.
Earlier, you mentioned the victim going to the hospital for checks.
Yes.
Looking at Ghana's healthcare and forensic infrastructure, do we have the equipment, the trained personnel, the institutional capacity to adequately investigate rape claims and distinguish true cases from fabricated ones?
Yes, Ghana here, there are some capacity, but they are limited. So the Ghana Police Service have the centralized forensic science laboratory in Accra. It's only based in Accra, and so all the cases are being sent from across the country here to test, which is not helping. So there is inadequate facilities because it leads to delayed in getting the medical reports and then preservation of evidence and all that. So the infrastructure, there is, but it's not enough. It's limited.
Now, several research papers have...
And then the staffs too, the inadequate staffs too. Yes, because most of them, there are few doctors.
Okay.
And not all the regions in Ghana have the same experts as those that have been based in Accra, and so definitely they are also limited, and then their lack of trained that is their inadequate trained staffs for to handle such matters, to investigate it.
So would you say that's one of the reasons why some false, let's say some rape cases may be deemed as true when they are false? Would you give that as a factor, the inadequate resources and trained personnel?
Yes, maybe the matter is true.
True when they are not.
Yes, in that instance, because if reports are delayed, then definitely it may not proceed.
Okay.
And so it just take it, we just take it like that, and it just land as that.
You know, there have been research papers that show that men are less likely to report sexual assault. Based on your perspective, what do you think the reason for this could be?
Yes, because of the social stigma and shame, and the fact that culturally we have a high expectation of men to be bold and to be strong, and that the women are the weaker ones. And so if a man who is supposed to be courageous and all that, and eventually people will even argue that they enjoy the most in the said sex, so why do you then complain? So they face some of this shame and then stigma, and try as much as possible not to even complain at all, because the cultural expectations of them too. Some too are lack of confidence in maybe the judicial processes, so they turn out not to come up.
Do you see this changing anytime in the future?
Yes, it has been there for a couple of times. And so through public education like this, for you to know all your rights, and the fact that if you are a man and then you've been a man cannot be raped in Ghana here. So even if a man is a victim of rape, that not a victim of rape, as a victim of maybe sexual activity of that nature, a man can bring out cases of indecent assault under our law.
For somebody who is either a professional or a student or maybe in public life, what practical, legally sound steps can that person take to protect themselves from being falsely accused of rape or engaging in rape?
Yes, so the first one is you have to avoid engaging in compromised situations like alcohol, drugs, and some instances where it's prone that you have certain sexual activities. Because it's basically serious. Because if you engage in sex with someone who is drunk and the person comes out later to say that I never consented, it's difficult for you to explain yourself. So you avoid such situations. And if a person is incapable of giving consent, like person vessel, someone who is sick and cannot respond to certain acts, you need not. And even impersonations, going to hotels to maybe a person went to a hotel with her husband, and then you quickly impose as a husband and have some sexual connections. All these compromised situations, you must avoid them. That is one. And two, okay, so that's one. Two, you have to set professional boundaries. So if she says no, as you even asked first, that you have to cease immediately. Don't continue on, because doing so opens up such allegations against you. So these are some of the factors that, or some of the steps you have to take to avoid yourself in compromising situations, and that of setting boundaries for yourself. And you have to also respect the views of others. When they say no, you need not engage in it.
Some people have gone to the extent of putting cameras, let's say, in their spaces, so as to record anything that happens. So in case there's any form of sexual encounter, they can say that it wasn't rape or anything. Would you recommend something like that?
I won't recommend that at all, because that is obviously also a rising concern on the social media platforms, where sexual encounters are televised or are recorded and then sent to social media, and then it causes a lot of troubles. So you don't have to record one, because you can't invade someone's privacy. You have to also seek the consent of the person, that it may be because you want to engage in it. Let me record it. So if the person says yes, that's fine, but then it should also never be released. Now, because I've also said that consent, once given, can be revoked, even if you put camera on a person and then the person clearly says, I'm no longer interested in it, you have to then stop. So there is no need for you to use camera on while having sexual intercourse.
How about recording?
You don't have to also record.
Not to be released, but for protecting.
Eventually, well, if it shouldn't be encouraged that you record sexual encounters, because it's private thing, and eventually, well, you don't have intention of releasing. But if you have such a recording, and maybe you want to tender in evidence to exonerate yourself, it also comes to the test of admissibility, whether the evidence you've obtained from a breach of a person's right or to privacy can be tendered in evidence. So the court would then have to vary and compare the situations, contrast the recording with the you bringing the recording to the court to prove your case, and then the person's right to privacy. When the court balance it, and normally if the court deems it fit that it be admitted, then fine. But ordinarily it's illegal to record sexual encounters, or yes, to record, whether through voice or by video.
So if there's ever a case where someone falsely accused of rape, and the accuser later comes to claim that it was wrong, it was a false claim, does the law help the accused, the person who was accused of rape, to rebuild their reputation and seek redress?
Yes, you can rebuild your reputation. One, it's good that the person has come out and said, one, it's not true. That is first one. So it means the public will be aware, and immediately some of what you've gone through would have been satisfied, but that the demand of apology and retraction has already been made. But you can also mount an action, obviously, for the reputational damage previously. That is the defamation.
defamation.
Yes. So because at this juncture it has not gone to court, but just mere allegations, there could be a publication in the news. So that is publication of false news we've done, and then we've discussed, and then the false communications. So if this thing does not get into the hands of the police, for maybe fabrication of evidence, deceiving public officer, when you go to court, perjury, for all these things to happen, it can be limited to one, the publication of false news. It's a criminal offense, and then false communication is a criminal offense. Then your defamation, you can seek for damages for that. You can also seek an order from court that all those platforms that the person reported, they must remove all the videos or publications that were made previously concerning you. So you can take the person on and take steps to protect your image.
Wow. But by the time they do remove all the videos, wouldn't have gone viral, or other people now will have that content and be reproducing it?
Yes, so this is also a challenge, but at least there's a court order. And so if you find it with any other person, that one, it depends also on the nature of the court order. But I know for sure it will be directed against a particular person, the one, the publisher. And so that would be an unfortunate situation where it has already gone to, people have been downloading it, and then they are watching it secretly. But at least you are okay. If the person says, there wouldn't be a video of it because it's not true. Yes, so it wouldn't be, it wouldn't hit you as much as when there is a video. Or maybe where the sexual encounter has been recorded and the person has falsely accused you, and there is a video, but it doesn't show, and later on you are convicted to that one too. You can avoid people, prevent those who have already downloaded that one, depriving them of the video. But then you can, because there's a court order for the removal of the content from the platform for the further damages.
Now, if you could speak directly to lawmakers in Ghana, what is the one most urgent reform that you will push for in how rape and rape allegations are handled under Ghanaian law to ensure that both genders, male, female, are equally protected, and so are their reputations?
Yes. So, first recommendation, you even mentioned one, but the first is the definition of rape. It's gender specific, and so they should make it gender neutral. That is the first one, where both male and females can be raped. And two, the definition of the same rape is limited to penile vaginal penetration, which is not helping, because penetration can be done through orally or anally. And so in all these instances, we should cover this as part of it, as other Commonwealth countries have criminalized it and make it gender neutral. That is one side. And then two, maybe the institutional framework like DOFSU and the police. There are some of the various regions in Ghana or rural areas or cities that do not have the enough infrastructure. So I recommend that Parliament see to it, so that there is some funds which is being released to make sure that adequate facilities and then these various DOFSU units and police units are up to standard to handle such matters. And I will also recommend that they can consider prescribing penalty, or maybe criminalizing and prescribing penalty for false rape allegations, specifically, so that we know that this is how criminally this is what it is. Because you have to, it just gives rise to other offenses like that, publication of false news, and then false communications, publication of evidence, but all this are specific, and there are specific circumstances that are these offenses arise. So what if the person never published it? it means fabrication of false news will then come. You get, but if there is a specific offense creating section in Act 29, as a criminal offenses at 1960 at 29, if there are specific provisions to that, I think it will help so that we know the actual penalty for it.
Speaking to our viewers, our listeners, do you have any final words for them?
Okay, I would say that justice in rape cases are two-sided coin, and whereas we attempt or try as much as possible to protect the complainant and to make sure that the complainant gets justice, there are many cases where there have been forged allegations of rape, and so the accused persons must also be equally protected. And so the investigators must always be objective, have a clear mind, and impartial in their investigations, and know that they can also go wrong and put an innocent man in jail. So all these things, the public must view it. And most importantly, if a court of law has never pronounced that someone is guilty of rape, we should reduce how we view those people in the eyes of the public. We shouldn't condemn them, because having damaged the person's reputation it cost the person so much, and then it's very hard for the person to win it back, because not everyone will even hear later on that it's not true, and then the person's image had been destroyed, lost employment, and all avenues. There is nothing that you can do that can eradicate it completely. Well, as I said, having been in prison for all these 19-20 years, the only compensation, small amount of compensation that will be given to you, that one your lawyer has to prove that you've even suffered something, and that the general damage that will be given to you may not be enough. So the public, I will urge you, should consider that, and then trust the judicial process, that the court is competent enough to see through that. Of all the material evidence that has been presented before the court, there is merit and prima facie case that rape has been established.
Before I let you go, if someone wants to reach you, how do they reach you? How do they find you? How do they find Zoe Akyea & Co?
So Zoe Akyea & Co is located at Laboni, and then in the Accra. We have our website online. So when you Google Zoe Akyea & Co, you can find us, and you can read more about us. You can get our contact and everything from there, and then our email too. We are always there to respond to your queries each time you reach out to us.
Amazing. I want to say a big thank you to the one and the only Mr. Charles Boakye, Esquire. But how can they reach you personally?
Yes, personally, you can reach me on my number 0547 48 93 80. 0547 48 93 80.
All right. Thank you very much.
You're welcome.
All right. And you just heard from the one and only barrister and solicitor of the Supreme Court of Ghana and the legal associate of Zoe Akyea & Co, Mr. Charles Boakye, Esquire. And we just touched on rape and forced rape allegations, looking at this touching issue from the eyes of the law. And that brings us to another end of the Kristocentric agenda. This week's episode. Next week, I'll be back same time, same place, with another interesting and heart-touching piece. Let me just put it that way. My name is Yeboah Edwin Techi, and I'll always say that God is not done with you. Your best is yet to come. Please enjoy the rest of your day. Akyea.